Good afternoon. My name is Sherry Sutphin, and I'm the Special Magistrate for Seminole County. The way that this process works is that the county will present its case first. It will present any witnesses and testimony that it has or any evidence. You can cross-examine witnesses that the county presents, but you cannot present any evidence or testimony until it's your turn to go. Once the county has closed its case, then it will be your opportunity to present any testimony, witnesses, evidence, anything that you have. I will make a decision here today at the close of both cases, or both sides. If you are here for the first time and are found to be in violation and you fail to come into compliance and this is your first time, you stand to have a penalty of up to $250 a day imposed. If you are here as a repeat violator, you stand to have a fine imposed of up to $500 a day if you are found in violation of the county's code. We are going to get started with the first case, and if when I call the case, if you'll come and have a seat here, then we will get started. So the first case is going to be 2366 CESM, Efrain Lima and Kelly Andres. I'm going to swear in witnesses first. If you'll go ahead and state your name and any appearance.
Kelly Andres.
Okay.
Attorney.
Yeah, can you state your name on
Deborah Nutcher.
Thank you. Okay, and so anyone that's going to provide testimony, if you could please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes. Yes.
Thank you.
You're going first. Sorry. Good, Karen. Where's yours?
Good afternoon, Officer Hill, Seminole County Sheriff's Office Code Enforcement, East Region. I'm submitting a copy of my PowerPoint to the clerk as Exhibit 1.
Okay. Have you given a copy to the...
I know the attorney has gotten one, but I can
Okay.
submit another one.
Okay, no, as long as they've received a copy, I think that that's fine. Do you have it? Oh, you have
We
not.
have no copy.
She gave one to me.
Oh, okay, I apologize.
Is there any objection to this PowerPoint being accepted into evidence?
Yes. We are objecting to the photographs.
Okay, let's let her go ahead then first. Before I accept it into evidence, if you'll go ahead and present your case, and then we'll discuss whether there's objection after that.
Okay. This is case 2366 CESM, Efrain Lima and Kelly Andres, located at a vacant property at Lowry Drive in Oviedo. Violations charged in Seminole County Land Development Code, Chapter 30, Part 7, Section 30.122, uses permitted. Storage and accessory structures on a vacant parcel is not a permitted use in an A1 zoning district. My initial inspection was on March 16th, 2023, with notices to the respondent on March 17th, April 6th, May 9th, and June 16th, 2023, with compliance dates of April 17th, May 7th, May 9th, and July 5th of 2023, with multiple follow-up inspections, including yesterday. The results of my follow-up inspection is the violation of storage and accessory structures on a vacant parcel remains on the subject property. This photo was taken by myself on the initial inspection on March 16th, 2023. These photos were taken by alert or a helicopter on June 11th, 2023, when they were out on air patrol.
Madam Magistrate, I don't know how you like to run the objections, but we certainly object to the photos taken overhead. as
Noted.
for illegal search and invasion of privacy. I think that those
This isn't
should-
a criminal proceeding.
But Fourth Amendment does apply to code enforcement matters, so.
Your objection is noted.
Is it sustained or overruled? or-
I'm reserving.
Okay.
Like I said to you at the beginning, I was going to let the officer present her case, and so that's what I'm doing.
These photos were taken on the same date. These photos were taken on the same date as well. This photo is an image of the email that I sent to Ms. Andres on June 14th, 2023, with the 3 attachments of the notice of violation. I was having a hard time getting a hold of them. Per property appraiser, that's who we legally cite by the address that's listed on property appraiser. It was a P.O. box at the time. It came back, sent back to myself because it was not a good address. So then I did a search in our cafe report writing system and found an email address. So I sent the notices to the email address as well. I also ran Ms. Andre's driver's license, got a different address than what was listed on property appraiser, sent the notice to that address as well. These photos were taken by alert on June 6, 2023. This photo is a posting. Originally, this case was going to go to Code Board in September, so I posted it for a hearing for Code Board. At that time, so I posted 11 days prior to the hearing. I got a phone call from Ms. Andres the day before, which was September 26th. The hearing date was September 27th. Ms. Andres had stated at that time she had not received any notices from any of the addresses or the email, and I had actually gotten her phone number from the building department and left her a voicemail, and I did not receive a phone call back. When Ms. Andres called on the 26th, she asked if I could continue the case to another date because she was not properly noticed. And after I spoke with her, I told her because there was no progress made towards coming into compliance, and I hadn't heard from her until then, that I would not continue the case, and then she could explain at Code Board what was going on with the property and the reasons for no contact. So Ms. Andres said she was working towards compliance by getting a permit for a primary structure. So I told her I would contact the county and talk to them. So I spoke with Ms. Parkhurst, and she had said that there was no permit in the process for a primary structure, and that they also had violations as well, and suggested that I take this case to special magistrate instead of Code Board. So I filed the affidavit of withdrawal from Code Board and submitted my statement of violation to Ms. Parkhurst for today's hearing. These photos were taken from alert on September 26, 2023. These photos were taken by myself the day of posting for special magistrate on November 6, 2023.
Show me what I'm looking at the pictures that you took.
So this is supposed to be a vacant parcel, which means nothing should be on this property. So these are, the one on the left, I believe, is a storage container. The one on the right is a large metal building.
Okay, and then what about the fence and?
That's going to be with the building department, but that is my posting out front of their property.
Okay. Okay.
These photos were taken by the same date, on the same date. These photos were taken by myself on yesterday, November 15th. These photos were taken yesterday as well. These photos were taken as well. The right is blurry, but the arrow is pointing to a camper that is on the property. These photos were taken by alert yesterday. Same date. The suggested recommendation is based on testimony and evidence presented in case 2366 CESM, is determined that the respondents, Efrain Lima and Kelly Andres, are the owners of record located on the vacant parcel Lowry Drive in in Oviedo, as determined by property appraiser records, in possession or control of the property, and is in violation of Seminole County Land Development Code, Chapter 30, Part 7, Section 30.122, uses permitted. It's further recommended that the special magistrate issue an order for the respondent to correct the violation on or before midnight of January 16th, 2024. In order to correct the violation, the respondent must remove the unpermitted storage and accessory structures from the property. If the respondent does not comply with the order, a fine of $100 will be imposed for each day the violation continues or is repeated after compliance. This concludes my presentation.
Okay, so tell me a little bit about the alert system.
Sure. So when we can send an email to alert, and if they're in the area doing area patrol, which they do on a daily basis, if they're in the area of a property that has a code violation, they take photos or video footage.
Okay, and who and what is alert?
It's our helicopter, the sheriff's office helicopter.
Okay, and they are just regularly patrolling by air?
Correct. They have to get flight hours, and so they will patrol unless they get called out for a certain call for service by deputies that they need alert for.
Okay, and so when they're patrolling by air, what types of things are they observing typically?
So if it's for a deputy, it could be for if there's a burglary in progress where they're looking for suspects. If it's for code violations, we never ask them to directly go to a property. It's only in the air, only if they're in the area, hence the word area patrol.
Okay, and so is it a constant taping, and then when you receive the taping, do you hone in on photos you need?
They'll fly over the area if they're in the area for an area patrol. They will take constant footage, and then they'll either clip photos from the footage themselves, or they'll send me the footage, and I just go in and, like you said, hone in on certain areas and clip and use the program Paint to crop out like neighboring properties.
Did you provide the cropping of this video footage, or was it done for you?
The footage was sent to me by our aviation unit.
Okay, and then did you hone in on the specific properties?
Correct.
Okay, so the photos that you have shown in this PowerPoint were created by you from footage you received from the alert unit when they were in the area?
Correct.
Okay, would you like to indicate now your objection?
Yes, I object to the photos taken by the helicopter, unless the person is here who took the photos, even though she may have zoomed in and cropped them. I believe that's still an illegal search. And also, where's the person who actually took the photos to demonstrate that this is true and accurate representation taken at the date and time indicated?
Okay, the objection is overruled. I'm going to accept the documentation presented in the electronic case file into the record. In this case, are you finished with your presentation?
Yes, ma'am.
Okay, now I'll entertain your case.
I'm just going to give an overview of some of the legal issues, but I will let Ms. Andres speak on the factual issues, if that's all right.
Absolutely. It's very informal, so however you want to handle it is fine.
I'm also a special magistrate, so I'm usually over there. I spoke with Mr. Lima and Mrs. Lima last night because late in the day yesterday is when they finally received the code file in this case. For a long time, they didn't even know what the violations were. And Ms. Hill had been on vacation for quite some time, and they were not able to contact her prior to the date of the previous code board set hearing. Ms. Hill has testified that notices were issued March 17, April 6, May 9th, and June 16th. However, where is that it? Are there any other notices, and where is the proof that that was actually sent certified mail? Because I don't think the code file that we got indicated that how the notices were sent. I'm not going to testify, but I believe Ms. Andres will testify that they did not receive the notices. Also, I don't see that the officer put the notices into evidence, but the notices, I don't believe, say anything about accessory structure. I believe that the notices just say, where's the
Storage.
notice? Storage, and I don't think it says anything about an unpermitted structure on the notice, on the notices. While we might
It's
want
a different case, isn't it? There's a subsequent case that we have today as well. That's a building case. This is a zoning case.
Yes, I'm talking about the zoning case.
Okay.
It's, pardon me, but it says remove the unpermitted storage/accessory structures there, and it's not on the notice.
Right, though what she's got written on her PowerPoint is not the same thing that's included on the warning notice of code violation. It says storage on a vacant parcel not permitted in A1 zoning. Nothing about an accessory structure. Also, Ms. Andres received a withdrawal and a closing of the case that relates to all of her prior inspections. So all the notices that she alleges were sent in March, April, May, and June, all related to a different code case. And there was a withdrawal of that code case, and Ms. Andres was informed that that case was closed. And that was in late September when that case was closed.
Do you have a documentation of the closure?
Yes.
Can you provide that to me, please?
Yes.
It's going to take a minute to look at it.
The letter to...
I've got to find it. It's in one of these folders. It's not there. There's the mailing letter.
There are a lot of notices there for you not to have received them.
These are affidavits of mailing.
Yeah.
Oh.
These are copies from them.
Well, these are from what she got from the public records request, not what she had actually received.
She did a public
It may have
records
gotten mixed in.
request.
Oh, I'm going to find it. This is the affidavit of mailing the withdrawal.
Well, here, this is the affidavit of mailing of the withdrawal and the closing of the case. May I approach?
Yes. This same case number?
No, ma'am.
It's a different case number.
23-41, which was the subject of the inspections and...
But not the case that's for us today. So the case that's before us today, 2366 CESM, has not been closed.
Correct.
Okay.
The point that I'm trying to make, maybe not very well, is all of the inspections that were done were for the other case, and all of the notices that allegedly went out were for the other case. Now that they created a new case, they closed that case, then they created this case that we're here for today, but did not issue a new notice. There was no new notice of violation with time to comply pursuant to 162.06, I think, and that was not done, and that's required to be done before you can take a case to either code board or the magistrate. So at this point, I don't think you have jurisdiction because they did not follow the process in Chapter 162 to bring the case forward. No notice of violation was issued for this case. No time to comply was issued for this case.
Okay, let me ask the officer, do you have the notice of violation that was sent or posted?
I have all the notices that were sent.
For this case.
The case never changed. It was going to be brought before the code board But then when Ms. Andre says she could not make it because due to a meeting conflict, I told her I would get with the county because she had said she was in the process of getting permits for primary structure. Because that's what she needs on this property before she can have anything on this property. She has to have a primary structure, which she does not have. So I contacted the building department, spoke with Ms. Parker. She said there was not an application and process for a primary structure. She had said they also have violations that they were taken to special magistrate, suggested that I close out my case, which is just filing the affidavit of withdrawal.
Which is what this is.
Correct. Not closing out the case.
Okay.
Not reissuing notices, because plenty of notices had gone out all different ways, via email, via different addresses.
But it
And when
says
there's-
closing the case. It says on there, closing the case.
And when the sheriff's office and the county both have violations for the same property, the county likes them to come to one avenue, which would be special magistrate in this place, because a building department does not get heard before the board, the code board.
Okay, this is just the affidavit of mailing. Can you show me the affidavit of withdrawal?
May I approach? Yes.
Yes.
May I go to my case?
So how did you reinitiate? What was the document that reinitiated the case under this different case number?
So we file the affidavit of withdrawal, so that takes it off the code board agenda. Then I file another statement of violation, which was the same dates for the notices, for the inspections, but for special magistrate.
And do you have that document?
The statement of violation?
A statement of violation is not a notice of violation.
No, it's not. It's a case package that we submit to the clerk, so she opens up the case and gets it on the docket.
The problem that I'm having is that it was withdrawn. And it doesn't say withdrawn and assigned a new case number under the special magistrate process. So I do find it interesting, though, that your client did not receive any notice, but they magically received the notice of withdrawal. That's kind of interesting.
This is from the case file that she had to ask for pursuant to a public records request.
So none of the postings that were on the fence or anything were seen?
This is, all that they got was, there were two postings of the notice of hearing, not notice of violation, but the notice of hearing. These were posted outside of the fence, and these are the only things that they received. The first one was posted on September 15th, and I believe after that is when they tried to call, and Ms. Hill was on vacation before the hearing was supposed to be held. And they were trying to get information because they didn't understand what that meant, no storage. And the only thing that Ms. Hill said is you can't have anything.
Well, why don't you let your client testify as opposed to you testifying?
Correct.
So before I get to that, Officer Hill, did you indicate in your notices that the removal of the unpermitted storage, were you referring to everything on the property as storage since nothing was supposed to be there without a primary structure?
Let me pull it up in a second. So my notice said, Seminole County Land Development Code, Chapter 30, Part 7, Section 30.122, storage on a vacant parcel is not a permitted use in an A1 zoning district. Corrective action required until a permit and certificate of occupancy is issued for a primary structure by the Seminole County Building Department. All accessory uses must be removed from the property.
Okay, so it does talk about accessory uses, not just structures. So ma'am, have you received that notice that spelled out what the problems were on the property, even if it was under a different number? Had you received that notice?
At the time that it was posted for the notice of hearing only. We had not received the violations prior to that.
So you were able, and you have your affidavit of mailing, your affidavit of posting?
Per Florida statute, we do not need to do an affidavit of mailing. We don't send anything certified mail, only the clerk does. Everything goes out by regular mail. We legally send the notice that's on property appraiser, and that address was no good. That notice of violation was sent back to me as undeliverable. So then I ran our driver's license. I sent it to that address. Then in March, she requested to change her PO box, the one that was not deliverable, to her mailing address, which was the address listed on her driver's license. So that got changed. But all the notices were sent there, as well as to her email address. And then I also attempted to call her, and I left her a voicemail, and I got no return call.
Did you post in addition to all of these things as well?
I posted for both hearings, the code board hearing, that's when I first heard from her after the posting, and then for the special magistrate hearing, and everything is attached to that orange piece of paper that she showed, the statement of violation, the notices, property appraiser sheet, et cetera.
So the orange sheet that you received, ma'am, did you, there was nothing attached? You just simply received the orange sheet?
No, there were attachments with these warning notice of code violation, and that was all, and the statement that she stated. But again,
So then you did receive all of the warning notices telling you about the violations that were on the property attached to the orange sheet?
in September, yes.
Okay. And so you hadn't received them before September, even though they were mailed to your address, but you did receive them when they were posted?
Correct.
Okay. And do you receive mail at that address?
Which one?
I don't know, the one you had, the one you used. Do you
Yes.
receive mail at that address?
Yes, we do.
And you receive regular mail, your bills and other regular mail at that address?
We get most of our mail at that address, yes.
Is there another address you get mail at?
No. But
So,
we do have we've had mail lost, I can say that. So.
okay. And so did you receive any of these mailings returned?
Only the one that was for the PO box. The other one that was on her driver's license, no.
Okay. And how many, a notice of violation, I think you gave me 3 dates for sending the notice of violation?
One was sent March 17th. That was to the PO box that was the one that got returned. Then I ran her driver's license and sent that notice on April 6th to the driver's license address. Then, because I wasn't getting any response, I just attempted Lowry Drive, because that's how this all started, was that the United States Postal Service was attempting to deliver mail. They contacted addressing to find out if that was a good numerical. Addressing said no, it wasn't, and that's ended up going up to the building department, and then to me. That's how this complaint came in. So I'm just going to attempt the Lowry Drive address, which of course got returned because it's not a correct numerical.
And it's not a correct numerical because there's no primary structure
Correct.
on the property?
Correct.
Okay. And so you, in September, so about 30 days ago, you received the orange notice with everything attached to it, correct? Okay, and in that notice, how many days is she given for correction?
It had already passed.
So the initial notice for the good address, because I had to start because the PO box one was sent back to me. She was given almost an entire month, from April 6th to May 7th, to come into compliance. And then like I said,
Sir, you can give testimony yourself separately if you would like. She needs to give testimony herself without you providing it for her. Thank you.
Then when I attempted the Lowry Drive address, I gave from May 9th to June 9th. And then for the final notice, again, because we have to attempt, even though it's not a good address, what's legally posted on Property Appraiser, it was June 16th through July 5th, and then I sent it to the address on her driver's license, again, the same date, June 16th to July 5th.
Okay, so once it was posted in September, did she make contact with you and try to rectify the situation?
She did contact me, like she said, I was out of the country on a mission trip. When I returned her call. We spoke the day before the code board what was going to take place, the code board hearing. And she had asked if I would continue it because she was just notified. She had told me she had not received my email, my phone call, and any of these notices.
And what date was that?
That was the 26th, September 26th, because the hearing was going to be September 27th.
Okay, so when you did receive notice to be here today, you had from the time that you spoke with her until today, and you knew what the violations were, correct?
We understand that the violation that's written is storage on a vacant parcel is not permitted. However,
But what about the other documents that were attached to that the officer just read from, where she said that those documents stated that you are not to have any accessory uses of the property?
Well,
No, I'm not asking you, Counselor, I'm asking her.
I'm making legal arguments, though.
But I'm asking a question of your client, and I would like the factual answer first.
we don't understand what Ms. Hill is stating has to be removed from the property. It is an active construction site. We have an open building permit there.
And did you not just testify that there are no open building permits on this case, on this property?
For a primary structure, but they can attest to what's going on as they have other violations out there. I cannot attest to building department violations. But I will tell you, when I did speak to her on the phone on the 26th, I explained everything to her. And that's when she said, well, I can't make the meeting. I have another meeting that I have to attend at that time.
Okay, and so did she not explain to you when you talked to her on the phone what the violations meant?
She did not. My statement was that we would actively work towards getting, if she's stating it's a primary structure is the issue, but we do have an active construction permit, which I'm not sure about.
When did you pull that?
This has been, this is a copy of the renewal that was processed September 18th, 2023.
Okay, so September 18th, when did you receive those notices of posting?
It was September 15th.
So 3 days, and so you came down here and you understood something because you pulled a permit.
Yes, we reopened a permit, yes.
Okay, so there was a prior permit that expired?
Yes, that Ms. Hill did know about.
Okay, so you knew about it too, though. I know that Ms. Hill knows the law, but you knew about a permit because you had one and you let it expire.
Essentially, yes.
Essentially, or just yes?
I'd like to speak to my attorney for a moment.
Well, your attorney has put you on the stand, and this isn't a criminal matter, so I'm asking you questions, and you need to answer them.
Yes, the permit expired.
Okay, so you knew you had to have a permit on the property. You let it expire.
I did not know I needed to have a permit in order to have storage on my agricultural property. I was not aware of that at all.
Is this property zoned, what?
A1.
Okay.
And it's not a permit. I believe the permit is for an accessory structure. There's no permit for a primary structure. You have to have a permit for a primary structure before you can be issued a permit for accessory structures and storage on the property.
See, we don't agree with that. When you look at A1 and look at what they're actually citing, it doesn't say you have to have a primary structure, because this is A1.
Okay, well, that's Land Development Code 101, that you do have to have a primary structure before you can have an accessory structure. So I'm not going to entertain that argument.
But you do need to look at the actual code that they're citing.
Yes.
And I have not seen anything in any of the documentation where they're citing to any particular section of 30.122 that is in violation. 30.122 says within the A1 agricultural zoning, no building, structure, land, or water shall be used unless otherwise permitted except for the following uses. And there is a very long laundry list of uses that they can do on the property. So I do not think it is accurate for the officer to keep saying you can't have anything on the property for A1 because that's not what 30.122 says.
Okay, ma'am, tell me what's on the property.
There is trailers, a building, a gazebo.
Does the building have a permit?
This is the permit.
Did you get it, you received a permit?
Yes, this is the permit.
It was issued.
Correct.
There's an issued permit.
There was a 2017.
You want to, have you been sworn in? Let's go ahead
I
and
did
swear you in.
I did swear in.
Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Okay, and can you announce your name and title,
Vicki
please?
Hathaway, Building Inspector for Seminole County Building Division.
Thank you. So, Ms. Hathaway, can you explain to me if there are any building permits that have been issued on this particular property?
There is a permit issued in 2017 for a shed/barn. There is no permanent address or parcel here for an actual dwelling itself.
But there was a permit issued for an accessory structure?
In 2017.
Okay, and so if you can't have an accessory structure without a primary structure, how was there a permit issued?
That was with a different building official, and he noticed that when they did the inspections out there, that it was being used as like a primary residence, so then he pulled the permit.
So is the permit active right now and valid?
It's open, which it would be expired at this point in time.
So then, the document that you have is you reapplied for it September 18th, you told me, but you don't have the permit, you just applied for it.
No, the permit has been reopened. It is in an open issued status currently.
Which permit number are you referring to?
The 174091.
4091, correct.
Correct. It's
It's just
open
an
and
issued
issued.
status. That's
So
it.
what's issued status mean?
It just means it's open.
So that means it has not been issued or it has?
It has been issued, but they will not allow the structure to be out there because it doesn't have a primary dwelling, and there is no septic system out there. So in order to have the building, they would have to have a septic system.
But how do you issue a permit if it's not allowed?
Megan, I'm going to let her speak.
Okay, and
So,
I need to swear you in,
yeah,
please.
I was sworn in.
Okay.
Megan Zanorski, Project Coordinator, Planning and Zoning.
Okay.
So my understanding is, I was not here at the time, the 2017 was issued as a barn/shed.
So an agricultural
An
use.
agricultural use, which would have been permitted on an A1 zoning district. The current use as it exists is not an allowable use on an agricultural zoning district. Storage facilities, storage of this nature would not be an allowable permitted use. And an accessory structure such as this, even with a statement of intent, this is not a bona fide agricultural use without a primary structure, would not be permitted, would not be approved. So they may have an open permit that may have been reopened. They also have two other open permits that I've rejected currently, that are open for comment, that have not been returned to me with any response to comments for over 30 days. So there has been no active movement on those either.
Okay. So you made a statement that you have an ag property. Is it a certified ag use? Do you have the certified agricultural exemption through the property appraiser where you have a bona fide ag use being made of the property?
No, I'm not aware of that.
Okay. Okay.
Is that on the property appraiser? Yeah, the property appraiser. Yeah.
So what else is on the property?
Well, can we, can we get back to the issue of how this came today when they closed the case and did not issue a notice of violation with required time to comply for this case number?
No, I'm not ready to be there yet. Can you explain to me what is on the property different than what you've already told me?
There's not much else to,
You told me that there was a shed. You told me that, okay, I will ask you separately in a second.
this is my husband.
Okay, but I'm asking you right now. I want to know from you what's on the property.
A building, trailers,
What kind of building?
the permitted 4,000 square foot metal building.
Okay, it's a metal building. Is it being used for farm activities?
Yes.
So what type of farming activities are being done in that building?
We have storage of materials, feed. We have plants, and we grow different crops out there.
Feed for what?
We have chickens. The chickens are we just got rid of the chickens. We had feed there for said chickens. We're working on getting a new lot of them.
Okay, and what else is going on in the building? Are you living in it?
No,
Okay. What other structures are on the property?
that's it.
Okay. Are you living on the property?
No.
Do you have a different address that you live
Yes.
at? Okay.
Yes.
And so I saw something that looked unfinished. It was, if you could take me back to that photo, the photo you took, that. What is that?
That is a pole barn with storage in it.
A pole barn is not enclosed. That's enclosed on the side.
It's storage.
So it's not a pole barn?
Well, it's got a sidewall so we can shelter.
But a pole barn is poles and a cover. And do you have a permit for that structure?
Pole barns don't require a permit, to my understanding.
Okay. Sir, did you have something you wanted to add? Could you let him come to the mic, please?
Oh, yeah. So I've been doing the construction in that building for a while now. So a lot of the stuff is construction debris, construction material that we have, like the container. That's where I got all my tools and equipment to proceed, because we've been working in that property little by little. So if we have a little bit of time, I'll come in there and keep working like pavers and upgrading the plants, the banana trees. It's just agriculture. That's what we do as a second. And then we breed, we got a big pool for the fish too, and to create more fishing. And it's just, but they never give us the opportunity to explain to us what permits we need. I got GC involved in this to pull any permits they need, and I got an architect and engineer to work with them on whatever they need. But this just came up and didn't give them enough time to do anything. So I'm actually glad that we're here, because I think with you on board, they were willing to work more with me and communicate better. Like, I didn't know, we being on top of the GC about the other 2 permits that we submitted. Just today, this morning, they just told us that it was rejected. And we asked them this morning, what was the rejection about, what the architect and engineer needs to fix? They still don't know. So I'm really happy that I'm actually here with you, because I've been going on with this since 2017. I've been treating it very unfairly, and there's a lot of stuff in here that they just don't call back. They don't communicate.
Okay,
And
so
any permits that we need, if they will give us a chance, under oath, we have engineer, an architect, and a GC, we'll get any permits they want.
We just need to.
So I think
We need to tell us.
this is a different case, though. That's the building case. So what we're hearing is that you have a bunch of storage on this property that is not permitted because you don't have an accessory structure on the property. or primary structure on the property. So do you all have anything that you would like to provide that refutes the argument that council read, that Chapter 30, Part 7, Section 30.122, there's nothing in that section that states that this storage use is not permitted without a primary structure?
And if we need a primary structure, oh, sorry, I'm so sorry. Sorry.
For the record, Megan Zanorski, Planning and Zoning. So permitted uses, I could read you the list, it's quite lengthy. Do not list storage. Limited uses also do not list storage. It's the way our code is spelled out, that storage is essentially a prohibited use because it's not spelled out in our code.
Okay, because it's not listed as a permitted use.
It is a prohibited use.
It's a prohibited use. So, and the only way to allow the storage would be to have a primary structure that is constructed on the property.
Well, it would depend on the type of storage as well.
Okay.
At a magistrate. So, for instance, if it was storage that was in line with said use, so if it was a bona fide agricultural use and they were storing hay and feed for cattle because they had a cattle ranch, that would be in line with use, that would be expected. Storing of RVs and mobile homes on an A1 use would not be intended and in line with an A1 agricultural. So it depends on what the storage is.
So the testimony that there are trailers stored there and those sorts of items are the items that you're talking about with respect to not being permitted uses in this zoning category.
Correct, and without a full listing and accounting of what's there, I mean, but from just the few photos that are there, it's not in line with a bona fide agricultural use. I get applications with statements of intent every day for a bona fide agricultural use where people have cattle, aquaculture, apiaries, and they have, even if they're in process of getting their G1 exemption with the property appraiser, they have a business plan. They have something
Right.
in line moving forward to do that. I'm actually working with a customer right now that's in line doing that. It's thought out, it's well planned, not multiple vehicles lined up with RVs. It's not safe for an agricultural use to have multiple things lined up like that. But back to the use, again, it's contingent along with what their use is. So if
There was testimony that there's a fish pond and some things like that, but there was also testimony that there's no bona fide ag use on the property.
correct. So at this point, if they were having a bona fide agricultural use, I think it would be up to the planning manager what she would allow on her determination. But based on testimony, they could file a statement of intent. I don't know that that would be sufficient at this point in time. It would be her determination. She may want to see full agricultural exemption from the property appraiser before she would allow a accessory structure without a primary structure at this point to be permitted.
Or the storage, accessory uses and storage.
Or even an accessory structure at this point.
But we're talking about accessory
The
uses.
storage would have to be removed until there was either a permitted accessory structure or primary structure that warranted the storage.
Okay.
Because storage in and of itself, without the bona fide agricultural use, is not permitted.
Okay.
So,
Yes.
real quick, too, so I can see, we have 2 RVs. We're only using 1 RV for the construction site. So that's one of those RVs, the construction.
That's not
trailer.
allowed.
Even if for the
No,
construction
no,
trailer?
sir, it's not allowed. That's what they're telling you, but I think you need to, unless you do some of the things that she has told
If-
you here today.
If they will let me put a house on that property, I'm willing to put a house and get the plans and turn in.
But sir, what we need to do is this is not the place for you to lay out that plan.
I've been trying.
Well, I don't know that you have, because I think that there's testimony on both sides. I think there's testimony from you that you contacted the officer while she was on vacation. She admitted to that, but I think there are plenty of times that you all have received mail that it's gone ignored. And then when you did receive the posting, and the only reason that I'm saying that is because your wife testified to the fact that you do receive mail there. And so it just is unusual that all of the mail that the county sent would not have made its way through, but all of your other mail does. And then when the county finally posts it and you see that, that's when you think that you need to contact someone. So.
I think you're making, I'm sorry, you are making a lot of assumptions that are not in the record.
No, I think they are in the record
Also-
because I believe that there is testimony that these documents were mailed.
That's not.
There is testimony that the documents were, that your client receives mail there. There is testimony, so I can make inferences based on the testimony that's been given by both your client and the officer.
So we do know that 162.12 has the exclusive process for providing notice.
So I'm getting
And
there.
162
So let me get there,
Well-
okay? I'm getting there. So you're here. And so I find that there has been adequate notice, because you wouldn't be here if you didn't receive the notice. Your client wouldn't be here if they didn't receive the notice to be here today.
Of the hearing, yes.
Of the hearing.
They have to provide notice of the violation.
Are you
from-
going to let me finish?
Oh, man, you're really jumping all over me. Okay, I'm just trying
Well,
to.
because each time I go to talk, you interrupt me.
Well, I mean, I believe I have valid points to make for the record.
Okay, well, I'll let you make all your points on the record as soon as I'm finished, because I'm going through all of the points that you've already made. So, you have made this point about not adequate notice, although I do believe that they did receive notice through the other case. I do find that your point is valid with respect to the other case being withdrawn. So, giving them notice to correct. So, basically, you want notice to correct prior to them coming in here. So, they said they didn't know what they had to correct, but from the testimony that they've given here today, they knew exactly what they needed to correct. They knew exactly what was going on. They knew that they had to have permits. They just chose not to continue to follow through with the discussion. So if the giving them time to have a discussion outside of this hearing room is what your desire is, then I can certainly give that amount of time, and I can give a number of days. How long do you think it would take your client to meet with the county to fix the problems that exist on the property with respect to the zoning violation?
Well, before I let them answer that, my concern is that there's going to be a finding of fact, conclusion of law and order, and there's going to be a finding of a violation before they have even had the chance to understand what she was talking about when she issued the notices and try to cure that just because they got the notice of posting of the posting of the hearing in September doesn't mean they were given a proper notice of violation with the opportunity to cure, because they weren't given an opportunity to cure for this case. So I would ask that it be tabled for 30 days for them to meet, and if there's not sufficient resolution or sufficient understanding, then bring it back the next month.
Well, that's exactly why I was asking how long it would take them to talk to the county. Because I did tell you that you had a valid point with respect to the withdrawal of the prior case.
Is 30 days, if they table the case for 30 days, is that sufficient time for you to meet with the county? I mean, assuming that the county is cooperative in establishing a...
And assuming your client's cooperative as well.
Yeah.
Of course. Yes. Yes. If we could ask for 30 days to table the case for the opportunity to meet with the county.
I'm actually going to do you better than that, because I think if we're going to be into Christmas time in 30 days. So what I'd like you to do is, I'd like you to have met with the county. The next meeting is the 16th, January 16th, is that correct?
That's a Tuesday.
That's prior to, the Tuesday prior to?
So the second, yeah.
January 11th is the next meeting? Okay.
We have a December 16th.
Right, I know. So I'm going to continue this case until January 11th. And I'm continuing it under the case number 2366 CESM. And I'm going to find on the record that case 2341 CEB has been consolidated into 2366 CESM. Although the notices are not clear, I'm going to find that they are consolidated into one another. And in the future, I think it's necessary that rather than withdrawing a case, you make it clear that it's consolidated into, or you're assigning a new case number or something along those lines. And then if you do that, it doesn't require that you would revive your notice of violation. You would just be changing the case number. And so that would be handled a little differently. That would give you that existence of that violation when you first issued it. And so I will continue this case till the January 11th date, at a date specific, where we will rehear this case as stated. You have been given ample information about what is wrong on this property. And so there should be no one coming back here saying that they don't understand what's happening on this particular case. And so that is my ruling. It is continued to a date specific, January 11th, just on this specific case, 2366 CESM. Thank you.
Appreciate it. Thank you.
Wait, we're at the next one, too.
So the next case that we're going to call is 2367 CESM, Efrain Lima and Kelly Andreas. I will remind you that you are all under oath, including you, Ms. Hathaway.
Yes, thank you. Okay, for the record, the name is Vicki Hathaway, Building Inspector with Seminole County Building. Case number 2367 CESM with Efrain Lima and Kelly Andres. This is for 3125 Lowry Drive, Oviedo, Seminole County, Florida. Violation charge, Seminole County Code, Chapter 40, Appendix A, Section 105.1. The description of the violation is installation of an accessory structure with awning canopy, entrance wall with electric gates. The initial inspection was done on 3/15 of '23. Notice to the respondent went out on 3/22 of '23, given compliance dates of 5/23/23, 6/5, 6/19/23, 7/10/23. Follow-up site visits, you can see the follow-up there, and also the inspections via computer and on-site. Results of the re-inspection, the violation still remains on the property. This is a picture or a slide of the property card that shows that Kelly Indres and Ephraim M. Lima is the property owner. This is the notice of the green card that was returned to us. These are a picture of the accessory structure, picture of the address there that's time-stamped, also the fence that we're questioning there as well with the gates. Again, this was taken on 3/16 of '23. This shows somebody coming and going off the property. Again, the picture of the fence and the gates. I've never been able to access the property to get on there, so my pictures are usually from the outside of the property. This is another picture that was done verifying the address. And again, front gates again. Accessory structure taken on 4/26 of '23. Okay, next slide. The electric keypad entry for gates taken on 5/10 of '23. This is a final letter posted on the property due to return certified mail that was done on 5/9 of '23. This is an aerial image taken from our Connect GIS Explorer on 2/15 of 2019. This is another aerial image of 12/22 of '20.
I'm sorry, I didn't hear. How did?
They're through GIS Connect.
GIS Connect.
It's an aerial that you can take of properties.
Is that a drone?
No. I don't know how they get their pictures. It's through GIS mapping.
Through the GIS mapping system that I'm assuming the county has the...
Usually every county has one.
Right. And you have the software and they upload and update their GIS
Correct. That's
pictures.
how they inventory things.
It's similar to Google Earth.
It's the same, pretty much the same thing, yes. Aerial image taken on Connect Explorer of 2/2 of '22. This is another aerial image of 1/17 of '23. This is where no permits have been issued to correct the violations. We've got 2 permits in PC status right now that have been kicked back for corrections and have been sitting there since September, which we just discussed earlier before the meeting. This is a copy of the permit application for the fence and the gazebo that's on the property. This is a copy of the Seminole County Chapter 40 Appendix A regarding the permitting requirements. The recommendation, based on the testimony and evidence presented in this case of 2367 CESM, is determined that the respondents are the record owners of the property located at 1325, I think that's backwards, should be 3125 Lowry Drive in Seminole County, as determined by the property appraiser's records, in possession and control of the property, and in violation of Seminole County Code Chapter 40 Appendix A, Section 105.1. It is further recommended that the special magistrate order the respondents to correct the violations on or before January the 15th of 2024. In order to correct the violation, the respondents shall obtain the required permits for the cited violation. If the respondents do not comply with the order, a fine of $50 will be imposed for each day the violation is continued or repeated after compliance. The respondents must contact the inspector to verify compliance. This concludes my presentation.
Would you like to submit this electronic case file into the record?
Yes, please.
Is there any objection to the electronic case file with the correction of the address to 3125 being submitted into the record?
No.
Okay, thank you. And that's all?
That concludes my presentation.
Okay.
Like Ms. Hathaway stated, we did speak before. We did not know. We have a GC who's pulling the permit. I'm going to be getting with them to get the comments, and we will work with our architect and engineer to get that back to them as quickly as possible. Again, like we said before, we want to do the right thing. We want to get rid of all this, come to compliance. We'll pull whatever permits we need and work with you guys.
Do you think you can do that? They have given January 15th, but since we're going to be back here on January 11th, do you think if I gave you until January 10th to come into compliance, that that would be sufficient time? Understanding that, we have individuals come all the time, and if they're working through the process and they're doing the things that they need to do, if you need additional time, you can certainly ask for it. But do you believe by January 10th, you could come into compliance with these matters?
Meaning, coming into compliance, meaning
For the
getting
permits.
a CO on the,
Getting the permits.
Getting those two
issued.
permits that
The
are currently open.
permits.
I believe that we can do that, yes, 100%.
Okay.
If
Do you have
I have to
anything
sit
else?
next to the architect and watch him make the changes, I will do that.
Madam Magistrate, Megan Zanorski, Project Coordinator. These are also accessory structures for the same subject property, which will not be issued until there's a primary residence.
Hold on.
So there's no way for them to get a permit?
Okay, so do we need to put a house in that property? If we do, to be able to avoid all these
I
problems?
highly suggest, like the Madam Magistrate suggested, that you come to the second floor
Here?
and schedule a meeting.
Okay, yes, ma'am.
And schedule a meeting with staff. I was just speaking with the Sheriff's Deputy Kara Hill. We need to get multiple staff members together to get a resolution to all of the issues that you have on your property, which may take some coordination since there are multiple issues. But this, again, would not be something that can be, these two permits would not be issued until there's a primary residence, as they are not tied to, even if they had a bona fide agricultural use, Madam Magistrate, these two structures would not be issued.
Okay, so I'm not one for setting people up for failure.
May I ask a question?
Sure.
Is that comment stated in the comments back from the building department?
It was not on my initial review, and I apologize for missing that. I review upwards of 60 to 80 permits a day. That was something that I missed in my initial review.
So what was the initial review comments? Do you have those?
That your site plan was incomplete. There was no survey. So I could not even tell what was on the property at that point in time.
Okay.
So go back so we can understand. So what happens if, so we can't get those two permits, I'm going to catch 22, plus the other active permit that we have. Do we need to pull?
I highly
The house?
suggest you come upstairs and let's discuss
Okay.
setting up a meeting so that we can get all the appropriate staff members on board, so that we can get you a full and complete resolution.
Right.
And discuss it with all the staff members that need to be involved, so that you have a complete process on how to move forward and bring this to resolution if possible.
Well, if we can move forward, yes, ma'am.
And
Okay.
I think Madam Magistrate was about to interrupt and say that, not set us up for failure. correct?
Right.
Sorry, we all interrupted.
No, that's okay. I think that the dialogue is good because you haven't been having it up until this point. So I think that it's important for you to see the players and the people that you need to be speaking to.
Absolutely.
So this is what I'm going to do. I'm going to find that you have received notice properly to be here today, that you are present, that you are represented by counsel, and that you have participated actively in the hearing today. I'm going to find that there has been evidence of a violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1, failure to obtain the necessary permits. I'm going to order that you come into compliance by July 10th. Or incur a fine of $50 a day. If by July 10th, you have not achieved compliance because you are actively working through the process, then I want to hear about that. We will schedule a compliance hearing. You'll get it on the order that you receive here today, that hearing date in July, and I want to know that you're making progress.
Absolutely.
And I'd like it to be completed by that time, but understanding that, the whole receiving someone to come out and actually build structures right now is a little difficult. So let's try for July 10th, 2024, and we will go from there.
Thank you.
Thank you.
Does that change anything for the first one, though? Okay. Thank you.
Thank you. The next case is 2287 CESM Maria Bonilla. And this is a compliance case. We heard this case previously. Oh, sorry about that.
Ay, tan linda. Bueno, ok. No quieres mucho. Ok.
Actual one. Got it. Got it. Yep. Okay. Ready? Okay, for the record, the name is Vicki Hathaway, Seminole County Building Inspector for Seminole County. This is in regards to compliance hearing here of 2287 CESM Maria Bonilla at 9709 Bear Lake Road, Apopka, Florida, 32703. Violation Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the special magistrate on September the 8th of 2022. An order was issued giving the respondent a compliance date of December 8th of 2022. An affidavit of non-compliance was filed by the inspector after reinspection on December the 9th, 2022. The notice, June 8th, 2023 special magistrate hearing date was canceled and was continued to August the 10th of 2023. On August 10th, 2023, an amended order was issued extending the compliance date to November 8th of 2023. An affidavit of compliance was filed by the inspector after the inspection on November the 6th of 2023. The estimated administrative cost for processing of this case by the clerk and the inspector, total cost is $755.27. Recommendation that the special magistrate issue an order reducing the fine to the administrative cost totaling $755.27, and order these costs to be paid within the 30 days or the fine will revert to the original amount of $17,200 and constitute a lien on the property. This concludes my presentation.
Would you like to submit the electronic case file into the record?
Yes, please.
Okay. Ms. Bonilla.
My name is Maria Bonilla.
Oh, should I just ask her that question if it's okay to submit it electronically?
Okay, yeah, are you interpreting
just-
for her?
yeah,
Okay, so let me go ahead and swear you in as a
Okay.
translator. Do you solemnly swear to translate from Spanish to English and English to Spanish to the best of your ability?
Yes.
Thank you.
Okay, lo que ella está preguntando es que si pueden someter todo lo que la señora la inspectora...
Can you try to speak into the
Oh,
microphone?
sorry.
Yeah.
Quiere saber la señora que si usted autoriza que pueden someter todo lo que sometieron electrónico, si lo pueden someter con su permiso. Todo lo que la señora
Sí, sí,
presenta.
claro.
Yes, of course.
Okay. Do you have anything that you would like to add?
¿Usted quiere agregar algo de lo que la señora dijo? ¿Quisiera decir algo?
No, yo hice todo lo que ellas me dijeron, no sé.
She says no, but she's trying to do everything that you guys asked.
She's complied.
Okay, yes, she has complied at this time.
Que sí esté trabajado.
What the county has demonstrated is that the property was not in compliance originally, and a pretty hefty fine of about $17,000 accrued on the property.
Lo que está mostrando es que usted sí ha trabajado con nosotros, pero originalmente usted debía como $7,000 porque no había sacado un permiso.
But since you are in compliance, the
Pero-
county has agreed to reduce it to just their costs.
Okay. Pero como usted ha trabajado con el condado ha decidido reducirle el costo del, what's the amount, I'm sorry?
$755.27.
Probably should have grabbed the pen, I'm sorry. Lo bajaron a 700, 500 con un poco de cambio, no sé exacto. Oh, thank you. How much was it, sorry?
$755.27.
Que si no hay,
27.
¿será que si no hay manera de que ellos me descuenten eso?
She says, is there a way for you guys to discount this?
Actually, this is discounted from $17,200.
Okay.
La señora dijo que originalmente fue 17,200 y lo bajaron hasta 700, 527. Es lo más que...
¿Qué chance me dan para
sí.
pagar eso hoy mismo?
She wants to know, by when does she have to pay this? Does she have to pay this right now?
Well, I was going to ask her how long it would take her to pay.
La señora le iba a preguntar cuánto usted piensa que va a demorar para que usted pague todo esto.
Yo creo que unos 15 días puedo pagar eso.
She says that if it's okay with you, 15 days.
Oh, well, I can give her 30.
Ella le puede dar 30. Okay.
Okay, thank you.
Absolutely. Okay, then I'll go ahead and order in 2287 CESM Maria Bonilla that the fine be reduced from $17,200 to $755.27, which represents the county's administrative costs in this action, to be paid within 30 days. If it's not paid within 30 days, it will revert back to the original amount of $17,200.
Thank you.
The order will also indicate where the payment needs to be made.
Okay.
Okay?
Si entendió lo que la señora dijo,
Sí, que los
que
tengo que pagar.
si no lo pagan los 30 días, entonces va a tener que pagar todo eso.
Uy, no.
Okay, thank you.
Thank you.
Pero ya quedó todo solucionado.
Sorry, ma'am, that's it? That's everything's
That's all.
completed? Okay,
You can
thank
go.
you.
Thank you, Amy.
¿Algún permiso, algún papel donde yo después de que pagues alguna nota que quedó todo bien?
I'm sorry, she just wants me to ask, once she pays everything, she will get a receipt, like, or a notice saying that it's done, correct?
Yes.
Okay, thank
Thank
you so
you.
much.
Okay, the next case, 2346 CESM Rico Properties LLLP. Yes, can you identify yourselves for the record, please?
Brian Reese, I'm the property owner.
Okay,
Randy Bumbleau, architect, registered in the state of Florida.
okay. Can you both raise your right hand? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you.
Okay, for the record, name is Vicki Hathaway, building inspector with Seminole County Building. This is in regards to 2346 CESM Rico Properties LLLP. Brian C. Reese, registered agent, 2710 Pemberton Drive, Apopka, Florida, 32703. Notice of hearing was certified mail. The violation, Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. The case was originally heard by the special magistrate on July 13th of 2023. An order was issued giving the respondent a compliance date of September 15th of 2023. An affidavit of noncompliance was filed by the inspector after reinspection on September the 19th of 2023. Recommendation that the special magistrate issue an order constituting in the lien amount of $3,100 for 62 days of noncompliance from September 16th of 2023 through and including November the 16th of 2023, and a $50 per day, at $50 per day, and the fine shall continue to accrue at $50 per day for each day the violation continues or is repeated after November 16th of 2023. This concludes my presentation.
Okay, can you go through with me on the presentation showing where,
Yes, ma'am.
showing that the permit has still not been pulled accordingly?
This is a warehouse that had a second floor level put up that was second floor. I've been in there several times, and I guess I've talked to the tenants that were in there, which are now new tenants. But you can see where the construction has happened from a prior tenant. And these are just pictures of the inside of the building where the second floor is without a permit, which is what we need.
And there's still not a permit pulled today?
No, ma'am.
Is there an application that's been filed?
Get to the screen, please. There is one on status from 2022, but it's in PC, which is plan check because it's been kicked back for comments.
And is it related to the work that you've observed?
Let me look at my PowerPoint to refresh my memory, if I could,
What's the
please.
permit number, Vicki?
I'm sorry?
22.
I need to look at the permit. Rico Properties, I got it right here. This was heard quite a while back. Let me see here. Okay. Says here, the screen shows an application was received on 12/31 of '22 to correct the violation. This application is currently under review and has not been issued as a permit. Planning and Development Site Plan Review completed with corrections on 11/1 of '23. Review Coordinator completed with corrections on 11/1 of '23. Impact Fees completed with corrections on 11/1 of '23. Plan Review corrections pending applicant accepted on 11/1 of '23. Mechanical Review approved on 10/27 of '23. Plumbing Plan reviewed and completed with corrections on 10/27 of '23. So there's a lot of corrections that we're asking for.
Okay, so those aren't complied with, those are just corrections that...
Correct, for the application on file.
Okay, okay, so there has been some recent communication, though, correct?
Permit application is currently in PC status, pending mechanical and plumbing.
Okay. So still not in compliance as of today, or the date that compliance was supposed to be achieved, September 15th. Would you like to submit your electronic case file into the record?
Yes, ma'am.
Is there any objection to the electronic case file being provided?
I'm sorry, I didn't hear the question.
Is there an objection to the electronic case file being presented into the
No.
record? Okay. Do you have anything you'd like to add?
Well, I can tell you the story. I bought the building in 2021.
Sir, let me stop you right there.
Yep,
The case has already been heard.
okay.
So-
I didn't know about the July 13th hearing.
Okay.
When I called about it, I was informed that I was emailed, and I never got a certified letter, as far as I recall. Now, if they've got a signature on that hearing, then I'd like to see the signature on that one. But I really don't recall that one. Now, I did get this recent one for today.
Do you have the order so I can see?
This property, I've posted it several times.
Now, that I
Right, but
did
the
find
order,
out, but
I
only
wanna-
just recently, because I don't go to that property like all the time, and you know
I'm usually
that.
aware of those type
Right.
of situations, which is why I go in and talk to the tenant itself.
Right,
Because I'm like, I don't
whirlpools.
know who the owner is, I've not talked to them. Typically, they'll call me and say, hey, what's this for? And then at that point, we start working on our relationship to
Right.
get this thing going and, get you permitted. That's my goal.
Right, and I've left it up to Randy Bumbalow, my architect, to get the permit for us. So I'll let you speak.
Okay, before you do that.
You bet.
I actually, this case was presented in front of me. And Okay, so their evidence was submitted to show that the notices had been properly given.
Okay.
And in accordance with the statute. And so then that's how the order gets entered, because notice is properly given. Even if you're not here, you're deemed to have received the proper notice to be here. And so you, that's how the order got issued. Did you receive a copy of the order?
I can't recall.
Okay. And we do have, okay. Okay. Did you receive a letter on October 11th with an order attached to
I
it?
can't recall.
Above it? Okay. Okay. If I could have you, let me get some testimony from you, please. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
And state your name, please, for the record.
Liz Parkhurst, Acting Clerk to the Code Enforcement Special Magistrate.
Okay, and did you mail on October 11th a letter with the order which indicated the compliance date?
Yes, ma'am.
Okay, of September 15th.
Yes, ma'am.
Do you know if it was mailed prior to that?
I'm not sure. That was the previous clerk.
Okay. Okay. Do you have something you'd like to add?
No, we're just trying diligently to try to get a permit, and Randy's been working on that, obviously, for almost a year. And just recently, we found out we needed to hire a civil engineer to shoot grades where the new handicap parking space is going to be. I met him out there on Tuesday and held the stick while he shot the grades, and he should have the site plan done with topo tomorrow.
Your Honor, if I could add a little bit of detail to that portion. I was hired end of last year to obtain a building permit for Mr. Reese. I've known him for over 10 years. I can speak to his character. He's an outstanding citizen, and he's a developer and owns properties. He purchased this property as an investment and was not aware that there were code violations or parts of the building that were constructed without a permit. That was, in fact, the case.
When did you purchase the building?
2021. And at the time, Sonny's Car Wash was in there with a long-term lease, and they needed more space, so they moved to a new facility, but they were going to honor their 5-year lease. But we let them out of it because Pearl Pools came in and wanted the building, and quite honestly, they paid their leases for $15,000 a month. And since this has all gone on, they're not occupying the second floor, and I've reduced the rent to $7,500 a month until I can get the permit and get the stairs built and get the hallways done. And the electrical is already, they've gone in and done the electrical from what I've been told, and I've written the checks and paid the electrician. But we're just back and forth trying to get a permit.
Okay. Ms. Hathaway, can I speak to you, please?
Yes, please.
Okay. Because you were not present at the hearing, and I don't know for certain whether you received the order. Based on your testimony, I'm going to trust that you did not receive the order, or you would have brought the property into compliance. And so I'm going to actually extend your compliance deadline to January 10th. So you will need to come into compliance by January 10th, or the $50 a day that was previously imposed will be imposed. So I'm going to amend the order that was entered previously. Give you through January 10th, or $50 a day will be the fine, and we won't be as lenient next go-around. So that means I need you to stay with this. I know we're getting through the holidays, so that's why I'm giving you
We are
into
very,
January.
I'm sorry to interrupt you. We're very, very close.
Okay.
I think you're,
That's correct. We have all the building permit items checked except for one, which is to obtain a site development permit. We applied for that. We have a letter of approval from the site development folks. The last item on the checklist for that is to have a pre-construction meeting. The application for that had new requirements. St. John's letter, the measurements that they took this week. We will file those, set a date for the meeting, which I hope we can get in November, December period. And then with the site development, the site permit goes to the building department approves the building permit, and then they can start the correction work, which is actually somewhat substantial.
I can tell you this, the county's not going anywhere. They're here, they're open every day, and they're easy to find. So it really is going to be you making sure that you follow through with what you need to do. Okay?
now, does that mean, a clarification, does that mean obtaining the permit and starting the construction? Not
Obtaining the
finishing?
permit.
Pardon me?
Obtaining the permit only
Okay.
by January 10th.
And the $3,100,
That is actually, I'm amending the order.
Okay.
So your compliance date extends out to January 10th, so that
Fine. Thank you
has
very
not
much.
accrued yet.
Can I just verify with Mr. Reese? Your email is breese80@hotmail.com?
correct.
Okay. Thank you.
Okay? Do you have anything further?
Nope, that's
Okay?
it. Thank you.
Thank you. Next case, 2348 CESM RB Highlight LLC. Hi there. Can you
Good
identify-
afternoon, Special Magistrate. I am Attorney Joseph Kovashesh from the Lowndes Law Firm.
Okay,
Rafael Gonzalez, Attorney Church.
fantastic. Are you going to provide testimony? Are you going to have him provide testimony?
He may,
Okay.
Special Magistrate.
Do you, sir, can you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Okay.
Okay, for the record, name is Vicki Hathaway, Seminole County Building Inspector for Seminole County Building. This is in regards to case number 2348 CESM, RD Highlight LLC, in care of RD Management LLC, Corporation Service, CO, 6405 South US Highway 1792, Fern Park, Florida, 32730. The hearing was posted, actually. The violation, Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. The case was originally heard by the special magistrate on August the 10th of 2023. An issue was ordered giving the respondent a compliance date of October the 13th of 2023. An affidavit of noncompliance was filed by the inspector after reinspection on October 17th of 2023. The special magistrate issue an order, recommendation that the special magistrate issue an order constituting a lien in the amount of $5,100 for 34 days of noncompliance from October the 14th of 2023 through and including November the 16th of 2023 at $150 per day, and the fine shall continue to accrue at $150 per day for each day the violation continues or is repeated after November the 16th of 2023. This concludes my presentation.
Can you go through with me that there are no permits as of today?
They have applied for permits, they've not been issued yet.
Okay, and when did they apply for the permit?
Originally, let me look. This goes on for almost, let's see, we have a new report that was generated on 11/16 that they applied for their permit. They've got one piece is approved, corrections are required on a lot of it. We've started over with them once before. They've had a couple of pre-meetings with us. Originally, I want to say the actual permit was applied for, let me go back through the records, 4/13 of 21. The most recent, the plans review corrections were most recently submitted on the application on 8/2 of 23.
And anything after 8/2 of 23?
No, ma'am. Let me look here real quick. 11/14 of 23, we've had comments go back. 11/14 of 23, 11/13, 10/17, 10/12, 10/16 of 23, 10/13, 10/17.
So there have been exchanges working toward trying to secure the permit
Yes, ma'am, 2 different times.
since the August 2nd. There's been a couple times in October and then a couple times in November.
Yes, ma'am. They've had 2 plan review meetings with our plans people, and the first plans that were submitted, they pretty much told them you just need to resubmit everything again because it was lacking so much information that they just couldn't do it. So they've met with them several times and just said it'd be better if you start over again.
Okay. Do you have the order that was entered? Okay, you were not present when the order was entered, but I did find that sufficient notice was given. That hearing was held on August 10th. Okay. Yes.
Thank you, Special Magistrate. I'll sort of start with the end first. We are going to request an extension of the compliance deadline or a continuance of this compliance hearing. I think the efforts for compliance are important. I'd like to just clarify those efforts for the record. Now, with me today are representatives of Journey Church. That's the facility occupying the old Highlight building that is attempting to do this work inside a small portion. It's a relatively small interior modification of a much larger building. The church obtained the keys to the facility in March, I think March 3rd of 2021.
Through a lease? Do they have a lease? Or
Yeah, it's a lease.
Okay, okay.
The photographs in the code enforcement presentation are dated March 10th. You can hear, if you think it's relevant, the church hadn't actually started any work at that point inside. Whatever was there was a relic of prior to its lease or its occupancy of the building. It did hang some curtains in the front, which is depicted in one of the photographs to keep the risk of theft down to keep people from looking inside. There was a problem with individuals outside the building. But the initial permit, the initial commercial permit application was filed April 13th, 2021. And what happened, there was a misunderstanding or miscommunication between staff and the applicant as to the scope of renovations. Evidently, the county thought it was an entire redevelopment of the site. The applicant was only seeking permission to do minor interior renovations to 3 rooms to use as a, a part of the church facility. So a lot of time was wasted back and forth with that misunderstanding in place until the beginning of this year, when my firm got involved. There was a sit-down meeting with the county, January of this year. The issues were resolved. The current permit efforts were initiated at that point. There have now been 3 rounds of comment responses. The first round, 84 comments, and then 80 comments. And the most recent submission, which was a few weeks ago, was in response to just 8 comments. So we do believe the permitting application process is nearly complete. We do believe in the next few weeks we will get the final permit to proceed with what is a relatively minor interior repair. We respectfully request an extension of that compliance deadline or a continuance of the hearing today just to obtain that permit.
So let me make sure for the record, you represent the property owner, though, correct?
We have authority here, and as a part of the obligation under the lease, we're responsible for this proceeding.
So then as a officer of the court, you're stating that you have authority to represent the interest of the property owner, because it's the property owner that's been cited. So that's why I just need to make sure for the...
Yes, that's correct, Mr.
Okay.
Magistrate.
Okay. Okay. Do you think that you'll be able to do what you need to do by January 10th?
Let me address that this way. If the building department is satisfied with the last answers to the last 8 questions that we have, which they are still on the 2-week period of getting back to us, I don't foresee any issues with getting the permit and being done with that. However, the history have been that every time that we submit specific answers, they come back with more questions. So as of today, as he just mentioned, we answered the first 87 comments. After review, they came back with another 80 comments. After review, they come back with another 8 or 9 comments. So we have submitted all of those. We have put about $140,000 worth of monies in terms of engineers and surveyors and architects and so on to try to agree with all of the things that are going on there, even though this is a very minor interior alteration. Because of the history of the building and the previous owners are the management and many times that they fail through the process on getting in compliance, it has been a long dragging process, but everything that can be done to try to address the issues that the building department has brought us have been answered, has been provided. Again, this is a building of 1960 that has a lot of things that are already grandfathered there that we cannot change. And again, this is a 3-year lease with a 3-year option. So we should be very soon to be done with that permit if those last comments are sufficient.
Okay, I appreciate that, but I need you to understand that although your minor renovation, that might be, you had indicated that there were other changes that had been made, and so when you're coming in to get your minor revisions fixed, all of the wrongs that were done without permits are obviously needing to be rectified. And
Understand.
even though that may not be your problem, it is the property owner's problem.
Correct.
And so then it probably becomes yours because of the situation that you have. So I don't want you to think that the county is just making up things to
Oh, no.
continue the
That's-
process.
that's
It's-
understood.
It's
Yeah.
part of what they need to get compliance. So,
One of the things that we are dealing right now is that there are two old violations that are even on the record before we get to the property on 21. We have been helping RD management to clear those two violations. Looks like there was two permits that were open and never worked on. So we are also communicating for the last 2 weeks with the general contractor that opened those two permits to be sure that they are closed correctly and processed correctly. Obviously, it's not the church or our providers, so we depend on them going in and do what they need to do, but we are working on that also.
sure, okay. And I appreciate that as well. I just, I need you to understand the importance of coming to the hearings. I'm glad that you're here today. No one did come to the hearing in August, so it kind of makes it difficult for us to get business done.
As a clarification, Attorney McGregor Love did talked regarding that hearing, and we were informed at that point in time that it will be moved to the next meeting because of the fact that we have provided at that point in time all of the comments that were requested for. So that's the only reason why I were not there, but I do know that McGregor was together with the county lawyer in meetings regarding that, and that's why they take that decision.
Okay, so I don't have any evidence of that. I just have in the order, and I have a finding that there was sufficient information given about the notice. Nonetheless, you know now that it's important to come to these hearings.
Sure.
I appreciate what you've said and the attempts that you have made to try to rectify the situation. I would also encourage you to please have open communication with the building official, because the only way that you're going to be able to come into compliance is by communicating with her. And so I am going to give you a continuance till January 10th. You will have a compliance hearing that will be set for January 11th. If you have come into compliance, then you won't even need to come, but if you do not come into compliance, you'll have a fine, the same fine that was imposed back in the original hearing, $150 a day, that will accrue on the property until compliance is achieved, and I will be less lenient at the next hearing. I think that it's important for you to make sure that you continue following through with what you need to do to comply. Okay?
In perfect agreement, I will suggest, if possible, to confirm with the county lawyer, because there were a lot of conversations through that, and we were told that we did not need to show up to the hearing.
Okay, I certainly will do that. We'll have some communication here to make sure that if those communications do happen, that they make their way
Perfect.
to us.
Appreciate it.
Okay, thank you.
Thank you, Special Magistrate.
Okay, the next matter, 2350 CESM, Lena Della Russa Trust. If you'll go ahead and identify yourselves for the record.
My name is Dana Anderson. I'm the attorney for Rosemary Della Russa Brogna and her son, Edward Brogna, who's also here.
Okay. Are you going to provide testimony?
Yeah, go ahead and raise your right hands.
You both, do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Okay, we'll go ahead and get started.
Okay, for the record, name is Vicki Hathaway, Building Inspector for Seminole County Building. This is in regards to case number 2350 CESM Lena Della Russo Trust at 3232 Briar Way, Apopka, Florida 32703. Notice of the hearing was posted, Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the special magistrate on August the 10th of 2023, and an order was issued giving the respondent a compliance date of October the 13th of 2023. An affidavit of noncompliance was filed by the inspector after reinspection on October 17th of 2023. Recommendation that the special magistrate issue an order constituting a lien in the amount of $1,700 for 34 days of noncompliance from October the 14th, 2023 through and including November the 16th of 2023 at $50 per day, and the fine shall continue to accrue at $50 per day for each day the violation continues or is repeated after November the 16th of 2023. This concludes my presentation.
Ms. Hathaway, can you please go through with me the status of the permits
Yes,
on
ma'am.
this property?
We currently don't have any permits on this property at this point. I did go out this week and verify that the shed is missing. We've got a fence, we've got the shed there, that's gone. We've got a fence that's unpermitted on the property. We've got pillars that were kind of encased in the front of the patio area, and that requires a permit with the wrought iron fencing there.
So we have a shed that has come into compliance, but still remaining are the fence and the
fence
pillars.
And the pillars, correct, on the patio.
Okay. Can I see the order in this case, please? I do recall you being present.
Yes, Your Honor.
Okay.
You guys put it up.
No, actually, he does.
But I thought you're... But he put it up. That's the problem.
Go ahead.
Sorry.
No problem.
I was just, she was making a comment about the fence. Did you want...
Does the county, do you want to submit the electronic case file into the record?
Yes, ma'am.
Okay. And do you have any objection to the electronic case file being submitted into the record?
The only objection, I'm not sure I'd call it that necessarily, is that the pictures, obviously, that show this shed are out of date because they've acknowledged that the shed has been, in fact, removed.
Right. The record will reflect that the shed is no longer in violation.
Okay. Other than that,
Okay.
we don't have an issue.
Thank you. Okay.
And then, so part of the issue has been Ms. Della Russa Brogna is a beneficiary under the trust. She's a life estate with the power to sell. When they came to get the permits before, the county said you can't because you're not the Della Russa Trust. And so we had to submit the trust. And finally, back in August, after we came to this hearing, the county legal people looked at the trust and our positions, we'd explained it, and approved that. But somehow, left hand and right hand didn't know that. So when we came on Monday to pull permits to fix the fence and the front pillars, et cetera, they said you can't because you're not an owner-builder. And then after my client was home, he got an email from, I think it was Vanessa, saying, oh, I'm sorry, I misspoke. You were authorized to do that, but obviously we couldn't do that because we were turned away when we came here on Monday to try and get the permits. So the other issue with regard to the shed, the first thing we were trying to do is vacate the easement. There were utility easements, and so we could vacate those easements and get a variance for the shed. But Mr. Brogna, who was undertaking that, ended up in the hospital repeatedly with heart issues. He then asked us to take over that. When we did, we talked to Duke, and they said, no, you can't, because we're actively using it. So that's when we got rid of the shed.
Okay.
So we are trying, Your Honor, and part of the issue has been that, as I said, the county has originally taken a position that they now decided was not accurate, that we couldn't do things as an owner builder.
Did you get that interpretation from the county attorney's office?
For the record, I believe it was Jackie who might have sent the email.
But she forwarded an email from
The county attorney's office.
Okay.
Right.
It was not cleared yet at that point in time.
Okay.
Well, no, I think the county attorney's office emailed her back in August and told her it was clear.
I'm not privy to that information.
Okay. So now that we have this interpretation, and do you have any concerns with receiving the necessary permits for?
We'd just like to have an extension, because we did try and pull the permit, and
Okay.
they said you can't, and then they said, oh, I'm sorry, we were wrong, you can. We'd like to get an extension of 30 days before there's any fines to try and get the permits pulled and resolve the remaining two issues.
Okay, so what is our December hearing? 14th. December 14th. Okay, I'm going to give...
Jacqueline Perez, and she forwarded an email from Robert McHugh saying Rosemary Brogna is authorized to act as owner and owner-builder pursuant to Article 7 of the Lena De La Russa Trust. Appreciate the follow-up on this one. Have a great day.
Okay.
She had not recalled getting that email when my clients came on Monday.
Okay. I'm going to go ahead and give you an extension through December 13th, 2023, which is the day before the next hearing. There will also be a compliance hearing that will occur on December 14th that will be in the order as well.
Great.
If you do not come into compliance by the 13th, a fine of $50 a day will be imposed as in the original order, and you would need to come to the compliance hearing on the 14th.
Yes, Your Honor, and if we're making progress, I assume we can deal with that at that time.
Absolutely.
Thank you, Your Honor.
Thank you.
Thank you.
Okay, we're going to go a little out of order because I think we have some people present in the audience. Let's hear case 2355, CESM Emmanuel Hillary. And can you identify your name, please, for the record?
Emmanuel Hillary.
Okay, Mr. Hillary, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, for the record, name is Vicki Hathaway, Building Inspector for Seminole County Building Division. This is in regards to case number 2355 CESM Emmanuel Hillary for 2211 Broadway, Sanford, Florida 32771. The notice of the hearing was posted. Violation and charge is a Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the Special Magistrate on August the 10th of 2023. An order was issued giving the respondent a compliance date of October 13th of 2023. An affidavit of noncompliance was filed by the inspector after reinspection on October 17th of 2023. An affidavit of compliance was filed by the inspector after confirmation that the required permits were obtained on November the 14th of 2023. The estimated administrative cost to process this case to date totals $498.92 for both the inspector and the clerk. The recommendation that the special magistrate issue an order reducing the fine to the administrative cost totaling $498.92, in order these costs to be paid within 30 days, or the fine will revert to the original amount of $4,800 and constitute a lien on the property. This concludes my presentation.
Okay. Do you want to submit the electronic case file into the record?
Yes, ma'am.
Do you have an objection to the electronic case file being submitted into the record?
No, ma'am.
Okay. Can I see the order, please? Okay, I see the order that was issued by myself on August 10th, 2023. You were not present at the hearing, and there was a finding that you were properly noticed to be here. And then you were given a compliance date of October 13th, 2023 to obtain the permit. Go ahead.
Well, I put in for the permit on the 10th. The permit was approved on the 10th. And that's before the 13th. And it wasn't issued until the 14th, which was, I think, yesterday, or day before yesterday.
It's when I called the owner of the property and said your permit was
October
ready.
13th was when you were supposed to come into compliance, not November.
October the 13th.
Yes.
I did. If you look at the application, it was on October the 10th. When I did the application, it was approved. And the problem was that they was asking for money that I didn't feel like they should be getting.
I'm sorry?
That was October 10th.
He
He applied.
applied on October 10th.
Correct.
Okay, and when was it received?
That's when
It was
approved.
issued?
Yeah, it was approved on October the 10th. The problem was that they was asking me to pay for permits that I didn't have to have, permits that I didn't need. First of all, I bought the property from the county auction. The house was already tore down in a big pile there. I just took everything up, cleaned everything up, and just cleaned it off. There was no power there. There was no water there. And so they wanted me to get an electrical permit for $100 and something. They wanted me to get a plumbing permit for $100 and something. And they wanted me to get the demo permit, which I shouldn't have to pay for that, but I went on and paid for that. I paid for everything except the electrical and the plumbing permit. And I was trying to get the letters. You don't get to talk to people nowadays on the phone. You talk to computers. And I finally got a letter on the 14th, and I brought the letters up here. And that's when they went on and did what they had to do.
You got the letter on the 14th of November, or?
Yes, I got the 14th. I just got the letters from the 14th because I've been trying to get them. You don't talk to people that Florida Power no more. You talk to machines. And,
Oh, not from us, from.
No, not from you.
Not from
I mean,
the county.
You don't talk to them. You talk to computers, and then they say they don't going to do this, will never be done. So finally, I got a letter on the 14th, which I brought it down here time I got it. And that's when they...
And what does the letter say?
Say that there was no power to the building and there was no water to the building. And, I mean, they come out and inspect. I mean, the inspector come out and look, no house there. How could water be there? How could electrical be there? There's no way it could be there.
So we were requiring water and electrical.
When a demo permit is issued, if there's plumbing and electrical, we have to make sure it's capped off. I have the building official up here. I think he wants to speak, but it has to be capped off and done properly. We have to make sure that it's shut down correctly before we can issue anything, because we can't have live power on a job that we're going to issue a demo permit on.
Okay, yeah, and can I go ahead and get you to raise your right hand? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Okay.
For the record, Bob Pike, building official, Seminole County.
The reason that we have to make sure that the water lines are kept off and disconnected properly. I believe had a septic, that's a septic abatement permit on that, to make sure that the septic has been abated. There's reasons we have to do those for safety, obviously, with the demo permit.
Okay, and so did the fees in fact get paid ever for the permits? Did that occur on the 14th?
On the 14th, two of them, I actually called him and told him his permit was ready. And I said, Mr. Hillary, this is Vicki with Seminole County. I said, if you don't come get your permit, there's going to be a lien placed on Thursday on the property. So please come pick it up so you can be in compliance.
So then, to pick up the permit, did he have to pay ultimately for those two?
He has to pay for his permit.
But the water and the sewer?
The other ones are going to be issues through the utilities. We have to verify that they've been done. So that's what he got.
Okay, so you received it, but you didn't receive it till the 14th?
No. I paid for the permits, but I didn't pay for the electrical permit and the plumbing permit because I didn't feel like it was right for me to have to pay for electrical and plumbing permit when there's no building there.
No, but they were telling you that they needed to verify that they had been capped off properly. I mean, you can understand the safety concerns with making sure that electrical has been capped off properly when a building has been demolished.
I can understand that, ma'am. I'm an electrical contractor myself. But when there's no building there, the power had been cut from there for years. There had been no power to that house for years. There had been no water to that house for years. So, I mean, they come out and see the house is not there. I mean, we don't have no wire going to there, no wire hanging there nowhere. Florida Power's been disconnected the power from it, and they've been pulled the meter and everything from there.
Okay. Yes, sir.
For the record, we have to verify that. The only way to verify that is through inspection.
So is it fair to say that the county, for liability reasons, cannot assume that water and sewer are no longer running to the house regardless of how long something has been demolished? When you get a demo permit, the problem is the demo permit usually comes before the demolition.
Yes.
Is, I think, where the problem is. And so typically those would be things that occurred in normal process. So for them to issue a permit to you, they had to have those particular boxes checked, and they had to make sure that they were capped off.
But my point is everybody in the building department is certified for, I mean, they got electrical inspectors, if they go there and no wires going to the house, there's no water going to the house.
It doesn't matter, because they're still entitled to collect for those permits, and they're still entitled to go through their process, because even if they can see that, there's still administrative costs associated with the county verifying that. And the reason that those administrative costs are put into place is so that the Board of County Commissioners can keep taxes to a minimum. There are, the statutes allow the county to impose fees and costs related to their administrative work so that all of the taxpayers aren't bearing the burden for something that is happening on one property.
I understand that too, madam, but what I'm saying is, when I did the permit, on the 10th, when I paid the fines, I had already called Florida Power that same day trying to get a letter from them. I didn't get a letter from them. I didn't get a letter from them until the 14th. And when I got that letter from them, I brought it down to the building department.
And I guess the problem that I'm having is that the hearing was held on August 10th, and you weren't here, and you had from August, when you would have received the notice a few days later, you would have had almost 2 full months, but you came in the day before the permits were due.
It was on the 10th, and the permit.
Okay, so 3 days before. I mean, when you had 2 full months, if you had told me that you came in right after you received the order and you started the process and you were held up because of the utility company, that might be a problem that I would consider. But I think actually the county is being very fair because you could have incurred a fine in the amount of $4,800 for that month period. So I'm going to, do you have anything further that you want to add?
Well, I don't think it's fair for me to have to pay the $400 and some dollars because, like I said, I've tried to get the letters from the Florida Power, but like I said, you don't talk to people now.
But you didn't try until 3 days prior to compliance.
I didn't think it'd take, 3 or 4 days to do a letter, so that's what.
Well, and
yeah.
so that's part of the cost of doing business. I mean, you could have been here and you could have, a month later, you could have tried, but you didn't. You waited.
I was at the last hearing.
No, you weren't here because I actually have the order that says that you were not present. So.
That was a different one you were at. I was surprised you didn't show
Well,
up.
I didn't know nothing about that one. That's why I wouldn't, because if I could thing to show up, I will show up. Like I said, even on this one here, I didn't get a note. The only way I know about this meeting here is when I went into the building department. The young lady told me, she said, well, they going to have a meeting. She said, it'd be better if you be there. I said, okay. As far as the notice, I got the notice yesterday in the mail. That's when I got the notice yesterday. I got a regular letter and I got a certified letter yesterday. But I knew before yesterday because she told me Thursday or Friday when I came down here.
When was it sent, Ms. Hathaway?
I don't do the letters.
Oh, okay.
I don't know when it was sent, but I got it out in the mailbox yesterday.
I've posted the property 3 different times.
Okay, I don't go down to that property. I see you had to post it in the front of it, but I don't even go down there. I have no reason to go down there. So, I mean, if you post it to my house, I mean, that you posted one before from somewhere by my house, I got there.
I showed 2360 Church Street being his.
Right, that's my address. The one time you posted one there, but
Yes, sir, I remember.
it wasn't that one. If you post one there, I would get it, but like I said, I don't go down. I don't have no reason to go down there.
We have an affidavit of mailing where it was mailed to you on October 4th, and it did not come back in the county's file. So I would just recommend to you, if you find yourself back before a code enforcement issue in the future, that when there's a compliance date that's given, that you immediately start trying to come into compliance. I'm going to find that the fine that has accrued on the property is $4,800, but I'm going to reduce it to $498.92 at the request of the county. I'm going to provide you with 30 days to pay the fine. If you do not pay it within the 30-day period, it will revert back to the $4,800, and it will constitute a lien on the property. The order that is issued that you will receive will have the information on it on where the payment needs to be made.
Okay.
Thank you. Okay, the next case, 23103 CESM Thomas Courtwright Jr.
Yes, sir, I remember.
Hello there.
Good afternoon.
You want to go ahead and state your name, please, for the record?
Thomas Courtwright.
Do you want to raise your right hand? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Okay, for the record, name is Vicki Hathaway, Building Inspector for Seminole County Building. This is a special request for 22103 CESM Thomas J. Courtwright Jr. at 5675 Deer Path Lane, Sanford, Florida 32771. Violation charge, Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. Case was originally heard by the Special Magistrate on December the 8th of 2022. An order was issued giving the respondent a compliance date of March 9th of 2023. The respondent is requesting additional time to comply. On March 9th of 2023, the Special Magistrate issued an order extending the compliance date to June the 7th of 2023. On June 8th of 2023, the Special Magistrate issued an order extending the compliance date to August the 10th of 2023. An affidavit of noncompliance was filed by the inspector after reinspection on August 15th of 2023. On September 14th, the Special Magistrate issued an order extending the compliance date to November 17th of 2023. This concludes my presentation.
Okay. Yes, sir.
So we've gotten all the permits in place now except for one. I'm waiting on an engineer seal so I can apply for that permit. John Slats is my engineer. He has the paperwork. He said it's in the process, in the pipeline. I just need some more time for that one. The septic system permit held us up for better than a year. We finally got that resolved last 60 days ago. Since that's been resolved, we've got every permit except for this one in place now.
Do you know how long it'll take you?
We're dealing with an engineer. I'd love to say it'll be ready in 2 weeks, but, nobody seems to be getting in a big hurry lately.
Ms. Hathaway, has he been working with you?
Absolutely. I've got him
consistently?
in my phone.
Okay.
He knows who I am in his phone. We talk constantly, and I'm the one that told him, come back in and ask for additional time.
Okay, so is January 10th a fair, or do we need to go into February?
I would probably push it to February, because as soon as he gets the stamped engineered plans, he'll be sending it in here. We're kind of at the mercy of everyone else at this point in time.
Okay, can you tell me when the February hearing is? Do I have that in my calendar? No, see, I don't have hearing date. Oh, do I? February 8th,
Looking. Julie's looking.
I think. February 8th?
Yes, ma'am.
Okay. Then we'll go ahead and continue to, let's do compliance on February 7th. At 8 a.m. And then the final revert to the same amount that was in the original order, if not.
All right.
Okay?
Thank you.
Thank you. Have one, and I didn't realize, like, it gives me, but it doesn't have, I didn't see it, so I apologize. Okay, you ready?
I am.
Okay, let's do 2353 CES, no, wait, no, we did those together already. 2358 CESM, Sean Rodney and Glenroy Spencer.
Which one is it, I'm sorry? 58?
2358.
And we haven't done number 9.
Okay.
I don't have it.
Okay.
Oh, wait, I was looking at this. Maybe that's off. Number 9. Yeah, that's the one I just called. 2358, Sean Rodney and Glenroy Spencer. Okay.
For the record, name is Vicki Hathaway, Building Inspector for Seminole County Building. This is in regards to 2358 CESM, Sean Rodney and Glenroy Spencer, 1004 Oak Lane, Apopka, Florida, 32703. Notice a hearing was posted. The violation charge is Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the special magistrate on August the 10th of 2023, and an issue was ordered and an order was issued giving the respondent a compliance date of October the 13th of 2023. An affidavit of noncompliance was filed by the inspector after reinspection on October the 17th of 2023. Recommendation that the special magistrate issue an order constituting a lien in the amount of $5,100 for 34 days of noncompliance from October the 14th of 2023 through and including November the 16th of 2023 at an additional $150 per day, and the fines shall continue to accrue at $150 per day for each day the violation continues or is repeated after November the 16th.
You tell me from the order if the respondent was present at that last
They've
hearing?
never been present.
They were not, okay.
I've never spoke to anybody on this property.
Okay, and,
The letters came back for this hearing.
oh, they did. Even the regular mail?
Yep. I believe this is my mom. Yeah, that was the order. So they didn't, the order didn't come back.
The order
I
did,
mean, they
the
came
order
back.
came back.
Right. That we sent.
Did we we did not, we did post
posted.
the order as well?
It's been posted several times.
Okay, and so the order that was entered on August 10th was posted on the property?
yes.
Okay. And there, no permits have been even attempted to be pulled?
I've never spoken to anyone on this property.
And everything that's there is as old as 2021?
Correct.
Okay. Okay, I'm going to go ahead and ratify my prior order of August 10th, 2023. I'm going to impose a lien in the amount of $5,100 for the period of 34 days of noncompliance from October 14th through today. And I'm going to continue imposing the fine of $150 a day, and the fine shall accrue at that rate for each and every day that the violation continues on the property. Thank you. Okay, and I did skip number 5, actually.
55.
Yeah. 2353 CESM, Erlin Rodriguez Santos, and Mandy Reyes Hernandez.
Okay, for the record, name is Vicki Hathaway, Building Inspector for Seminole County Building. This is in regards to case number 2353, CESM, Erlin J. Rodriguez Santos and Mindy J. Reyes Hernandez at 3021 Freedom Trail, Oviedo, Florida, 32765. Notice of the hearing, there was a posting, violation charge with Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the special magistrate on August the 10th, and an issue was ordered giving the respondent a compliance date of October 13th of 2023. An affidavit of noncompliance was filed by the inspector after reinspection on October 17th of 2023. Recommendation that the special magistrate issue an order constituting a lien in the amount of $1,700 for 34 days of noncompliance from October the 14th of 2023 through and including November the 16th of 2023 at $50 per day, and the fine shall continue to accrue at $50 per day for each day the violation continues or is repeated after November the 16th of 2023. This concludes my presentation.
Okay, was the property owner present on this
No.
one?
They've never been present or contacted us.
And this isn't. Can I see the order? Okay, I'm going to go ahead and find that I'm going to ratify my prior order of August 10th, 2023, and impose a lien in the amount of $1,700 representing the 34 days of noncompliance from October 14th, 2023, the compliance date through today's date. I'm going to impose the continual fine of $50 a day for each and every day that the fine or that the violation remains on the property. Thank you. I think that concludes our hearings for today. So we will adjourn, and our next case, our next magistrate hearing will be held on December 14th, 2023. Thank you.